𝗟𝗏 Law is one of the top immigration law firms in the USA. 100 officers, including law clerks and case managers, work in different departments under the supervision of attorney Raju Mahajan and other associate attorneys in the United States. The success rate of 𝗟𝗏 Law is over 99% in fulfilling the dream of people from other parts of the world. Family-based, employment-based, asylum, and green card-related services are available under one umbrella in 𝗟𝗏 Law. In addition, this law firm is one of the best in the United States for obtaining services related to NIW, writ of mandamus, and student visas. The headquarters of 𝗟𝗏 Law is in Washington, D.C., metropolitan area. We have a branch office in Atlanta, Georgia, to reach the services easily of 𝗟𝗏 Law to everyone living in Georgia. Besides, we have a country office in Bangladesh. The contact address and phone number are shown for any immigration-related services. You can also email info@𝗟𝗏law.com. 𝗟𝗏 Law is your safe address for assistance and advice regarding immigration to America.
Hello everyone, happy Easter. Today we don't have any host. I will host the show. At the same time, I will talk about, first I'll talk about the P-3 visa, which is a lot of people call it artist visa. And then I will answer if there's any immigration related questions here. So let's start. Welcome to our show. Samir, can you please show the screen? Yeah, thank you very much. So as I said, P-3 visa is one of the very popular visa in America, and a lot of people call it artist visa. And many of you already know, probably our First Lady, Melania Trump, she came to America first as a P-3 visa holder, and then many things happened. I'm not going to discuss that detail here, but I'm just giving a context that P-3 is a very prestigious visa, especially those who are like a very famous artist, painter, or anything. This could be a very good path for you to come to America, do your work, and make money, of course. Next slide, please. All right, so the first question is, what is P-3 visa? The P-3 classification applies to foreign citizens who are coming temporarily, this is important, temporarily to the USA to perform, teach, or coach as artists or entertainers, individually or as a part of a group under a program that is culturally unique. So those thing I just highlighted in a bullet pointed, not bullet, like I made it bold. So it's a temporary visa. It's not a green card. It's a work visa. And you can come as an individual or as a group, and it must be culturally unique. So all this thing I'll discuss in this show, so you have a better understanding about P-3 visa. Next slide, please. So steps of P-3 visa, first, meeting the condition for P-3 visa petition. Of course, you have to meet the condition. Then you submit the petition. Here, you means you as a beneficiary, you cannot apply by yourself. It must be applied by your sponsor. The sponsor can be an individual person. The sponsor can be an organization. A sponsor can be a group of people. But the sponsor must be a registered entity in America. So this is a very important part. You cannot apply by yourself. You need an employer or agent or sponsor. Number 3, submit non-immigrant visa application to DS-160 by the applicant. Here, you can submit DS-160. You do not need a sponsor after approval of the petition. So once your I-129 is approved, you will go to your local US Embassy, and then you submit DS-160, you get it approved, get visa, and then come to America. Next slide, please. All right, so this is the steps step one, the meeting the condition for P-3 visa. Number 1, the sponsor is someone who wants to bring an artist, coach, or athlete to USA for a program or event which is culturally unique. Here, the artist, coach, athletes are referred as beneficiary. As I said, you are a beneficiary, and the agent or the company who is bringing you, they are the sponsor. The sponsor file an I-129 petition for the beneficiary. The beneficiary is someone, non-US citizen of course, who wants to come to the United States either individually or as a group for the purpose of developing, interpreting, representing, coaching, or teaching a unique or traditional ethnic, folk, cultural, musical, theatrical, or artistic performance or presentation. Additionally, he/she must be coming to United States to participate in cultural events that will further the understanding between these two cultures. Next slide, please. Here you must put a note. The program can be of commercial or non-commercial in nature. So a lot of people, they think that P-3 visa is for non-commercial purposes, for non-profit organizations. That is not true. You can come to America as a musician, as a model, as a any form of artist. You can work for-profit corporations. You can work for for-profit events. You can make money. So it can be of a commercial or non-commercial, either kind of nature. So you are okay about doing anything. Next slide, please. All right, let's talk about the application process. So the recent consultation, you need a written consultation from an appropriate labor organization. So this is kind of a little tricky, and I would say this is the number one complex issue for P-3 application. You need a written consultation from an appropriate labor organization. Let's say you are a painter, and let's say there is a painting organization in your area. So let's say New York City has like a painting group, and you need a written consultation that yes, if America allows this person to get P-3 visa, if he displays his artwork, it would be beneficial to America and for his or her home country. This kind of things. It's not very hard to get it, but it is mandatory. You have to get a written consultation from an appropriate labor organization. Then a copy of the contract between the petitioner and the beneficiary, or the summary of the term of an oral agreement between the petitioner and the beneficiary. Well, please remember that written contract is always better than oral agreement, because in USCIS, when we submit this application, written contract is very good, or summary of the oral argument is okay, but it's not that good. Then the next one is an explanation of the event and the itinerary. So you have to tell like when, how, where this event is going to take place, whether there will be ticket or not, who are you thinking of as a participants, and other thing. Like try your best to describe the event. In the events, our performance is going to take place in like multiple areas, and itinerary must submit. The itinerary must list the dates and location of the event. So try your best to explain everything about the event. That will help USCIS to make decisions. Next slide, please. All right. Affidavits, testimonials, or letters from recognized experts attesting to the authenticity of applicant or applicants' group skill in performing. So all it says is like you need recommendation letters, or like any kind of affidavits or testimonials about you, about your work, about the field. So the more you get, the better for your application. The next one is documentation that all of the performance or presentations will be culturally unique events. So this part is easy to do because any kind of cultural thing has some kind of uniqueness. So it's not that hard to establish. But yeah, you have to establish that the event you're going to participate, the art you're going to perform is culturally unique events. Next slide, please. All right. So please note that you have to file a filing fee if it is required. In some cases, there is no filing fee. In some cases, there are filing fee. It's like a $460 processing time, usually 2 to 3 months. If you do premium processing, usually you can do it within 15 days. There's an extra fee for premium processing, $2,500. So, but premium processing is always faster. So sometimes it's worthy to pay additional money. It's up to you. Next slide, please. All right, the step 3 is submit non-immigrant visa application DS-160 after approval of the petition. So this thing, I need to explain that thing. Lot of time, people already in America, let's say in a B1, B2 visa or F1 visa or other kind of visa. In that case, you do not need this third step. The third step is for the people who are already in a foreign country like Bangladesh, India, or Sri Lanka kind of countries. But if you're already in America with a B1, B2 visa, your approved I-129 is enough for performing your job as a P-3 visa holder. But if you're living in a foreign country, you need to submit DS-160. So a lot of people, they do not understand the difference between these two scenarios. That's why I thought I should say that. Next slide, please. Additional information. All right. So that even on the top of those things I just mentioned, by the way, in this kind of session, I try to just give you like a basic idea. I do not go deep into everything, because that is not the purpose of this video. So the entire point is just like informative session. So additional information: the applicant can take her partner and child, unmarried and under the age of 21, of course, to USA. So if you are like married, if you have a spouse and children, you can bring them with you. Period of stay depends on the duration of the event, not more than 1 year. So in the I-129 application, you have to mention how long this event will be or how long you want to be stay in America. You can say up to 1 year. Visa can be extended depending on the completion of the event. So sometime like even after 1 year, you can extend this visa and stay more in America. Number 4 is P-3 visa holder can change the status of the visa, meaning once you are in America under P-3 visa, you can apply for EB-1 or like other kind of visa categories. So even though you came to America with a non-immigrant visa, you can change it to an immigrant visa and you can stay in America with a green card holder, as a green card holder. So those are the good things about P-3 visa. The final thing is, note, for both cases, the form I-129 is used to apply for a change of status, extension of stay, or change of employment. Meaning, let's say you came to America under ABC Corporation to perform, musical thing, and then after 2 months, you got another job from another company called XYZ. So you can change your employment from ABC to XYZ by applying another I-129 form. Or you want to apply for extension of stay or change of status or anything. You can do that with filing another I-129 application. Next slide, please. Sorry. So this is the last slide, and that was our discussion about P-3 visa. Now, if you have any question about P-3 visa or any other thing, I'll be happy to answer. So since we do not have any host today, I don't know how many questions I'll be able to answer from my end, but if our technical team can show any question on the screen. Yes, there's a question. Can you explain how someone with pending asylum can apply for adjustment of status in the US with approved EB-3 I-140 if they have no other status? I have seen a few people got denied with USCIS in same case. So this is a complex question. Definitely those who are in America under pending asylum case, they can apply adjustment of status after approval of I-140. Definitely they need to wait for their priority date, I-140 priority date, to be present in the visa bulletin. They can apply for it. And yes, USCIS can reject this application. Also, I saw a lot of approval. So there is an example of approval and denial. So this is kind of a little risk if you are in asylum application. And a lot of time, the reason for denial is that before people apply for asylum, they had unauthorized stay. Let me give you an example. Let's say Mr. X came to America with a B1, B2 visa or F1 visa or something, and his authorized stay got expired. And after 2 months, he applied for asylum. Now his status is pending asylum application, but he has 2 months of unauthorized stay in America. When he will go for I-485 application or adjustment of application, this unauthorized stay will bug him. This unauthorized stay will harm his application. It doesn't mean that his I-485 application will be denied per se, but there is a chance. So the people you talked about who got denied, I need to see the reason for the denial, and I need to see the case itself, like from beginning to end, to see what are the reason I-485 application was denied. But I also saw a lot of approval in this kind of situation, especially those who do not have any unauthorized stay. They got approved very easily. So it depends on the situation. If you have more questions, I'll be able to answer it. Next question, Anuparna Shaha. I want to apply for F2 to F1 status change staying in America. In that case, I need to send financial support doc with the application. Will I send both my and my husband's account statement, or it will be better to send only one bank statement, either my or my husband's account? So you can definitely send one bank statement if that is enough. Let me give you an example. So let's say both of your tuition and living expense is total, let's say $40,000 US, and you have $40,000 in your account, then this one statement is enough. However, let's say you do not have $40,000 in your account, however, you have 20,000 and your husband has 20,000, then you can submit both statements. Combining both of your statement, if it meets the requirement, then you're good. Husband wife can submit their statement together. In America, husband and wife is considered as a single unit. So anytime, for any purpose, not only for immigration, for any purpose, when you need to show a income or asset, you can combine your husband's or wife's income and bank statement together, and you can show it to USCIS or any organization. They will consider it as a single unit. So yes, the short answer to your question, yes, you can submit both or one. It's up to you. All right, when doing adjustment of status, does USCIS look at your visa record as well? Of course, USCIS will look at your everything, your visa record, your past travel history, your past employment, your past residence, everything. USCIS will, especially because adjustment of status application is going to give you green card. America wants to be sure about your background. They just don't want to give you green card and then regret, like, oh, it was our mistake. They don't want to do that. So they will definitely check your visa record. On DSI 160, I missed one thing in the past, membership in social group, that I submitted in my I-485 application because I realized the group would fall under the category. Well, if you do any mistake like this, like, you when you submitted DS 160, you missed name of a group, and now you submitted, you must submit explanation. Like when you submit I-485 application, you must say, hey, when I submitted DS 160, I forget to mention this group because of this reason, blah, blah, blah. You have to submit an explanation with this application. And if the explanation is reasonable and convincing, then USCIS will accept it. So yeah, if you remember anything missing, as soon as you remember it, submit it to your application, add to your application. That will help you. I don't think we have any other questions at this moment. And this is a, Easter Sunday, so holiday here in America, also all over the world. So I really appreciate all of you watching this show and everything. And if you have any question anytime, feel free to reach out to us. Our website has all the information. Here you also get the name of our website, our email address, our phone number. Feel free to reach out to us. We'll try our best to help you. Have a wonderful day and happy Easter again.
𝗟𝗏 Law is one of the top immigration law firms in the USA. 100 officers, including law clerks and case managers, work in different departments under the supervision of attorney 𝗟𝗏 and other associate attorneys in the United States. The success rate of 𝗟𝗏 Law is over 99% in fulfilling the dream of people from other parts of the world. Family-based, employment-based, asylum, and green card-related services are available under one umbrella in 𝗟𝗏 Law. In addition, this law firm is one of the best in the United States for obtaining services related to NIW, writ of mandamus, and student visas. The headquarters of 𝗟𝗏 Law is in Washington, D.C. metropolitan area. We have a branch office in Atlanta, Georgia, to reach the services easily of 𝗟𝗏 Law to everyone living in Georgia. Besides, we have a country office in Bangladesh. The contact address and phone number are shown for any immigration-related services. You can also email info@𝗟𝗏law.com. 𝗟𝗏 Law is your safe address for assistance and advice regarding immigration to America.